Hello and welcome to the July 2023 episode of Outline, DLA Piper's regular series of planning law updates. This morning I'm joined by my colleagues, all legal directors in the planning team, Amy Truman, Stoneman and Ian Graves. So welcome to them. And we're going to be discussing the topic of environmental impact assessment, probably one of the areas that has been responsible for more planning permissions being quashed on judicial review when people get it wrong than any other area of planning law. So it's a topic that, although it's been with us for a long time, it still seems to cause difficulties. And part of that is the fact that it is quite a bureaucratic, quite an administrative process. And if you get that procedure wrong, which it's easy to do, then judicial review quite often follows. So we'll be trying to talk about how the system works and how to avoid some of the more obvious pitfalls that sometimes people fall into. As ever, for those joining us for the live broadcast, we'll try to answer as many of your questions as we can during the session. So please do use the Q&A function and we will try to get to those as we go through. We'll run for between 45 minutes and an hour. We always have a fixed stop at an hour, so we promise we won't take up any more of your time than that. So without further ado, let's get straight into it. And Claire, perhaps if I can come to you first, could you just give us a brief overview of the legislation that we're dealing with when we talk about environmental impact assessment?
Yeah, so the legislation which covers the EIA process is the Town and Country Planning Environmental Impact Assessment Regs 2017, and these regulations apply the EU EIA directive to the domestic planning system. And the aim of EIA is to protect the environment by ensuring that local planning authorities who are deciding whether to grant plan permission for a project, where a project is likely to have significant effects on the environment, they make their decision in full knowledge of what those likely significant effects are going to be. Schedule 1 to the regulation sets out where an EIA must be carried out. So these set out development over a certain size, and there's quite a wide range of projects covered, but really within Schedule 1, you're only looking at the biggest schemes. So I expect that quite a lot of people who are joining us today don't find themselves regularly dealing with Schedule 1 development unless they are infrastructure developers. And then you've got Schedule 2 of the regs, which sets out where EIA may be required. And this is where the development is in a sensitive area, or if it meets or exceeds exclusion thresholds set out in the schedule, and whether or not EIA is required depends upon whether that development is likely to have significant effects on the environment.
And I think for today, we are going to focus on that Schedule 2 development and that process, because I think you're right. Most of the audience probably don't fall into Schedule 1 on a regular basis, except those very big infrastructure and energy type projects. So we'll stick with Schedule 2, but just in terms of the legislation, you've talked there, Claire, about the English regs. Mm-hmm. Is the position the same across the UK?
Yeah, so each of the nations of the UK have their own set of EIA regs. So Wales and Scotland have their own separate versions. Because, as I said, they are implemented an EU directive, they do all follow the same process.
Probably worth saying as well, Trevor, I mean, obviously we're focusing on the town and country planning EIA process in the main, I think, but I mean, there are obviously different types of development have implemented the EIA directive in different ways. So, you know, agricultural development, for example, has its own set of regulations. There are some that relate to highways. Infrastructure development has a separate set of regulations, although the process, obviously the source is the Environmental Impact Directive. So that means that the sort of substance of the process is the same for all those different areas.
It's a really good point. There are those different for particular types of development, different types of activity. It's not just sort of traditional planning, is it? But yeah, I think, Claire, as you say, ultimately it all comes from the EU directive that tells us how EIA should be carried out. So the process we're going to discuss today is broadly the same across those regs and across the different parts of the UK. and theoretically across the rest of Europe as well, should have a similar process, certainly the rest of the EU at least. The rest of the EU, that sounded like we're still in it. Across the EU, I should have said. So, well, let's move on then to that first stage of the process. So, Claire, you've just helpfully said if you're in Schedule 2, if you come within those thresholds or you're within those sensitive areas, then the question is whether there are likely to be significant environmental effects as a result of the development that you're proposing. That's our legal test. And the first step of that process under the regulations is to screen development that comes within Schedule 2 in order to establish whether there are likely to be significant environmental effects or not. In terms of that process, Ian, can you perhaps just tell us a little bit more about the thresholds and about that test and how it applies to Schedule 2?
Yeah, thanks, Trevor. So I think Claire sort of touched on this, but I mean, Schedule 2 operates in a similar way to Schedule 1 in that it's a list of sort of project types. But I mean, the key difference is that each project type also has an associated threshold. And I mean, subject to a qualification that I'll mention in a second, a project only Schedule 2 development if it exceeds that threshold. So just to give an example, you know, in the case of something like campsites and caravan sites, they are only Schedule 2 development if the area of the project exceeds 1 hectare. And the various project types will all have one or more thresholds that has to be exceeded for that type of development to be Schedule 2 development. The only exception to that is, and I think Claire mentioned this earlier as well, but if the site is wholly or partly in a sensitive area, and that are things like triple SIs, national parks, AONBs, those sort of areas, if it's wholly or partly in that sensitive area, then you don't have to exceed the threshold to be a Schedule 2 development. And I mean, I think one point to make is, you know, it's fair to say, like a lot of legislation that comes from, you know, ultimately from Europe, a lot of the sort of project descriptions are a bit ambiguous as to what is included. And, you know, that's led to litigation in some cases. And essentially, it's a matter of planning judgment, whether a project falls within the description or not, subject obviously to challenge on public law grounds. So the requirement to be a Schedule 2 development is that you're in the list and that you exceed the relevant threshold. But there then is a further test that needs to be satisfied in order for you to be EIA development. And it's EIA development that attracts the requirement to do environmental impact assessment. And the further test, as you said, is whether the development's likely to have significant effects on the environment by virtue of its size, nature or location. And that is generally the judgment that's being made at the screening stage. So it is relatively uncommon for it to be around whether the development actually comes within Schedule 2. It generally is this point around likely significant effects. And in assessing that, Schedule 3 sets out a list of factors that the decision maker needs to take into account when considering that. So that is sort of broadly how the process works. In the planning practice guidance, there is actually an indicative screening thresholds sort of annex that sort of gives you an indication. So you can go and have a look at that, and that should give you as a sort of a bit of a rule of thumb as to whether your particular project is likely to be a project that has significant effects on the environment or not, and so attract EIA if it's a Schedule 2 development.
You mentioned the sort of slightly vague wording in some of the sections of Schedule 2. I think I've sometimes seen confusion because there isn't, for example, your residential development doesn't feature, but what there is, and the one that tends to catch most of our clients, if there isn't a more specific one, is urban development projects, which sort of, but it's one that if you read the list, you might sort of be forgiven for thinking, oh, I'm not on that list because I'm a residential development on the edge of a village or something. But actually, if the case law is clear, that is an urban development project. And I think that one's the one that is sort of a bit of a catch-all for most larger scale development that's going on, isn't it?
I think that's right. I think, you know, if you're over 150 houses, then you would be an urban development project under Schedule 2. And I think that's right. You know, that is the that is the description that's attracted some litigation. So there was a case a few years ago, the name that just escapes me for the second, but it was about effectively a storage, self-storage warehouse, and whether that's an urban development project. I think, you know, the way the courts have generally approached this is that, you know, if the local planning authority or the Secretary of State makes a sort of a legal error in terms of misunderstanding what the description is, I suppose the court can correct that. But where it's a situation where that, you know, the description can bear a number of different meanings, can reasonably bear a number of different meanings. So urban development project is a classic example of that. Then, you know, it is a matter of planning judgment, and as long as the local planning authority has adopted a view that is reasonable, you know, an interpretation that is reasonable, then the court won't interfere with that. But I mean, you know, I think urban development project is sort of slightly ambiguous. I mean, if you look actually at many of the project descriptions, they are quite difficult to sort of understand exactly what they're getting at in some cases. The agricultural ones, for example, you know, I've had a couple of projects where those descriptions have caused a bit of difficulty because it's just not always that clear exactly what it is they're intended to capture.
Yeah. And the Amy, the principle is that screening has to be done upfront at the beginning of the process, and various court decisions, the Supreme Court in Champion re-emphasised that point. But the position is a little bit more complicated than that in the context of multi-stage consents, which of course almost all planning permissions are, even detailed ones have conditions that need approving. So what's the approach, and how do we need to be thinking about screening when we're dealing with those different stages of getting planning approvals?
Yeah, I mean, any of these projects that we're looking at with EIA, we need to consider the sort of screening issues on every stage of that multi-stage consent. So not only the outline, but the reserve matters and discharge of conditions even might catch or trigger the need for EIA. So you need to be still considering whether there's likely to be any significant environmental effects arising on each of those that haven't been assessed in the original EIA undertaken. So one of the ways I think that you can sort of control this a little bit more is by considering your parameters that you're looking at when you do your first EIA on your outline. So if you set the parameters of the development coming forwards that you've tested against your EIA, then that and anything else coming forwards then falls within that reduces the likelihood you're going to have to do another one. But I mean, there are things still to be considered. There may be some effects that couldn't be identified at outline stage. There might be some that just weren't, so there was a failure to consider them at outline stage, and then they crop up at reserve matters or even discharge of condition stage. Some that might have been identified, but you need to undertake a fresh assessment. So if there's been a material change of circumstances, for example, might trigger the need to do something else at a later stage. So it's really on the decision making that the decision maker needs to have the significant environmental effects in mind. So and all of those are decisions, obviously, not just the outline consent. So in which case it's probably a good idea to screen it so that then you have a bit more certainty over what you need to do, or whether you need to do one going forward if there's any question marks. That's the best way to deal with it.
I think that's a really important point for me. I think yeah, the process is quite procedural, and if you miss a step, you are likely to be quashed if anyone brings a judicial review. And so it's, I think if you're an applicant for planning permission, while the obligations fall on the planning authority or the Secretary of State if you're on appeal, actually it's important as an applicant that you make sure the planning authority is doing it properly, because ultimately it's your planning permission that the risks being quashed. And I think that the multi-stage consent point is one where I'm nervous. I'm still not sure planning authorities are regularly thinking, if the development is Schedule 2, and if it is EIA development, as Ian's just explained, then it's not just screening at that outline stage or the detailed application stage, you've got to think about that reserve matters and the condition discharge. You only have to ask yourself whether there are any likely significant environmental effects that haven't previously been the subject of EIA. But if you don't ask yourself that question, then you're at risk of a challenge, even if the answer to that question would have been, well, actually, no, there aren't any, or there aren't any that haven't already been assessed. If you don't ask yourself the question, there is a vulnerability there. So I think that for me is a really important point, and I'm just not sure that process is followed routinely by planning authorities when condition discharges, for example, are coming through. So I think it's an important one for an applicant. If you've got a controversial proposal where there are risks of judicial reviews, even at that later stage in the process, make sure that you're forcing the local authority into going through that screening process to cover yourself.
I agree. I think it's really easy to miss because you feel like you've been through a big process up front, ticked it off, but actually you still just need to keep thinking about it. Yeah.
And I think on the challenges, one of the points I wanted to flag up was the question of judicial review, because it is judicial review where all the failings come out. There's a point to be made about when anyone who's wanting to challenge ought to bring a challenge. And for a long time, the courts have been quite clear, and the CAT case made it very clear that you bring that challenge at the end of the process, i.e. once planning permission's been granted, then you would challenge the decision to grant planning permission on the basis that the screening process was defective or any other stage in the EIA process was defective. So that's the sort of established conventional wisdom, is you do it at the end. Having said that, I think the champion case in the Supreme Court, which is a few years old now, going back best part of 10 years, the court did that wasn't a point that was relevant to the decision, so the court didn't rule on it, but the court did question whether that was the correct process, or whether actually, if you're criticizing the screening process, you ought to bring a challenge at the point that the screening process you identify that flaw. So I think it's one, if you're looking to challenge a planning permission on the basis of screening, you might want to get legal advice quite early on, because you may find that your time limit, your 6-week period to challenge, is running from the date of the flawed screening decision rather than the date of a later grant of planning permission. Equally, if you have a planning permission and it is being challenged, then one of the things you might want to look at is the champion case and actually see whether there are grounds for saying, no, you're bringing this claim too late, you're out of time, therefore, even if there was a failing, it's too late, there's nothing you can do about it. So I think that for me is quite an important point. And alongside that, sorry.
Yeah, no, sorry, it's interesting, because I think there's an argument for both of those being appropriate sort of justiciable decisions, isn't there? Because the reason that usually you would challenge the grant of planning permission is because the way the EIA regulations operate is to prevent the council from issuing a planning permission in circumstances where it's EIA development and there isn't an environmental statement, if you see what I mean. So it's a sort of a straight unlawfulness argument, isn't it? But I mean, equally, they are making decisions, that presumably are subject, where public law challenges are available at an earlier stage. So the screening process is a decision that's being made by the council, isn't it? By the public authority rather. So I mean, I think there's probably an argument that either it would be appropriate.
Yeah. Although they could decide at a later stage that they did need something. I suppose as the planning application moved on, they've got the ability to request further environmental information.
It's not a once and for all decision, is it? So I mean, I suppose at the stage of screening, if you send your letter for action, then the council has actually got an opportunity then, hasn't it, to rectify the situation. Whereas if you wait until the planning permission's issued, well, the council can't, that's it then, isn't it? Issue permission. So the only way that can go is by the court quashing the planning permission if the decision needs to be reversed.
I think that's right. Amy, we've had a comment come through that you're quite quiet. I don't know whether your microphone's in slightly the wrong place or something, but just pass that one on.
Okay,
someone else that you're certainly coming through louder for me now, so hopefully that's better for the audience. we've also, someone's asked for reference to the Champion case. We will provide all the references in the follow-up email, and they'll be posted in the description of the scheme on our YouTube channel as well. So we'll handle those out for all the cases we talk about. I think the other point, just in terms of while we're on challenge, there's always a sort of a need to be cautious and a desire to be cautious when considering EIA, and particularly at screening stage, in order to try and avoid unnecessary challenges. I think, though, for me, sometimes the tendency of a planning authority is to want to issue a positive screening decision, i.e. to say it is EIA development and therefore needs to be subject to environmental impact assessment. And there's a sort of tendency to say, well, actually, we'd better say it is in order to avoid a challenge. And I think that always strikes me as actually slightly odd, because as soon as you do that, you're then opening up the whole EIA process, which one is a lot more effort for everyone concerned, including the planning authority, but also there are then further steps in the process where there's extra risk of challenge. Actually, the decision on screening is one of planning judgment. And so if a negative screening decision is issued, provided that that's a reasonable, rational decision to have made, and provided you've taken into account everything you should have done and you haven't taken into account anything you should have, a negative screening decision is actually very hard to challenge. So I think, just as a point for people to bear in mind, a negative decision actually can be the least risky. If it's not, obviously, if it's EIA development, it needs to be EIA, but that sort of err on the side of caution and let's throw it into the pot in order to avoid a challenge, I think sometimes it creates more risk. So it's just worth bearing in mind, if it isn't EIA development, people shouldn't be afraid of saying, no, it isn't, and therefore I'm going to issue a negative decision. And get that decision right, and actually you then avoid all of the later risks that come with screening. Anyway, that's just personal little bugbear of mine. Let's move on. Claire, I think while we're on the subject of challenges, just if the local planning authority issues a positive screening opinion, how can an applicant challenge that if they don't agree and they don't think an EIA is necessary?
Yeah, so if you find yourselves in those circumstances, the Secretary of State actually has a power to make a direction themselves in relation to the need for EIA. So if you found yourself in a situation where you had a positive screening opinion but disagreed with what the LPA was saying, you could request the Secretary of State makes their own screening direction as to whether the development is EIA development or not. And just going back to the point that you made, Trevor, about a negative screening opinion, I think it's just worth mentioning here that there is also the ability for any person, whether they're an applicant or not, to write to the Secretary of State to request a screening direction in circumstances in which a negative opinion's been issued. And so that gives people a chance to challenge at that stage. And you can also request a screening direction in circumstances in which the LPA hasn't issued their opinion within the required 3 weeks.
Yeah, so it's a really good point, Claire. And actually, we've seen cases where third parties who are unhappy with planning applications and there's been a negative screening opinion, they have sought a direction from the Secretary of State, and sometimes quite late in the process. So it's just worth being alive to that risk, isn't it? That third parties trying to frustrate development actually may well use that Secretary of State screening direction process. Yeah,
exactly.
Having said that, I don't know what experiences of others on the panel, but I've certainly found that the Secretary of State over many years in various different guises, I'm not sure I've tried it under Gove, but various different Secretaries of State have tended to take a more pragmatic approach quite often than a planning authority. And so I've quite successfully, where I've had a positive screening opinion, had that reversed by the Secretary of State and got a negative one, or where the screening opinion lists 100 different things that need to be 100 different likely significant environmental effects. So throw the kitchen sink at it. Actually, the Secretary of State quite often will slim that list down, even if he or she doesn't reverse the point. So I think it's there's a danger of a third party doing it, but actually as an applicant, it can be quite an effective tool to either avoid the process if you think there's grounds for not doing an EIA, or just reducing the scope we'll come on to scope in a minute, but just reducing those potential likely significant environmental effects, and therefore sort of that feeds into scoping. But just before we get on to scoping, I think it's an important point, and one that often comes up, is the question of to what extent, when you're screening for likely significant environmental effects, can you take into account mitigation? Ian, I can see you nodding. So what's your thoughts on that point?
Yeah, I mean, it's something that's often debated, I think, isn't it, and quite often misunderstood. I think, I think that's because the position is slightly different between EIA and the habitats regulations, which I'll talk about briefly in a second. But like a lot of things in planning, it depends on the facts of the case. But basically, yes, mitigation can be taken into account. I mean, in fact, the EIA directive was amended, I think, maybe around about 10 years ago, to sort of expressly provide the opportunity for developers to give information about mitigation. And the most recent version of the EIA regulations in this country, when that was being consulted on, the government sort of expressly said that this was so that EIA was being focused really on projects where there will actually, in practice, be significant effects on the environment. So it really was trying to sort of narrow the category of projects that really fall into this. And when a decision maker has concluded that likely significant effects can be avoided through mitigation, it's going to want to record that in the screening decision. And then later on, obviously, those any mitigation measures will need to be secured in by a planning condition, for example, or by a Section 106 obligation. So, this is another way that, we can really sort of narrow the scope of projects that need to be subject to environmental impact assessment. And, as you say, I mean, sort of quite understandably, given the fact that there have been a lot of sort of legal challenges on these in this area over the years, this sort of defensive practice has arisen, whereby people are very sort of cautious, and if there's any doubt, things will be screened as having likely significant effects. And as you say, when we go on to scoping, we'll talk about that a bit further. But the reality is the sort of the express intention of the European Commission, and certainly the government in making the most recent EIA regs, was that only those projects that really will have significant effects should actually be screened in, and taking into account mitigation is part of that. I think one other just quick point is just about the different position under the habitats regulations, and this is something that does sometimes get confused. Without going into all the sort of detail here, that mitigation can't be taken into account at the equivalent sort of screening stage under the habitats regulations. And that comes from a European Court of Justice case called People Over Wind. So sometimes there is a bit of sort of confusion between those two systems. But in EIA, we can take mitigation into account at the screening stage.
It's that need to secure it, isn't it? Which comes up again. I mean, I think one of the things that lawyers do with environmental statements is we tend to be asked to do a legal audit of the document once it's been produced, and both at screening stage and at that stage. One of the challenges that I sort of constantly push back to the authors is, well, you've said this could be mitigated by. Is it going to be mitigated by? You can't leave it as a could. How, if we're relying on that mitigation, it then needs to be secured. Otherwise, there's an easy challenge at that point. If you've said you're screening it out because this mitigation could deal with it, but you then forget to secure that mitigation when you grant planning permission, then you're in a real problem. So that kind of making sure that what you've said you're going to do in terms of mitigation, you actually then don't just do it, but you actually secure its delivery, whether that's through planning conditions, through use of planning obligations, whatever. But it needs to be there in order to avoid falling into that trap later on, doesn't it?
Yeah, and being capable of sort of being secured is one of the things that the decision maker is going to take into account when it's deciding if mitigation actually will avoid the likely significant effect. So when I said at the beginning there that it's a very sort of fact sensitive process, that is one of the things that the decision maker will take into account. So if you've got something that's that maybe is not capable of being secured, or might be difficult to secure in a planning permission or in a Section 106 obligation, it might be that actually that isn't mitigation that can be taken into account at that stage. Of course, most mitigation that would be proposed will either be part of the development, or it will be something that can be easily secured under the consent. So you have things like codes of construction practice and those sort of things.
I think probably a last point for me, and then we ought to move on from screening because we've probably spent too long talking about it. But I think one of the very, very live issues within the courts at the moment is the question of where do you draw the line as to what is an effect of the development. And the Finch case, which we've talked about in a number of outline sessions before, and we will no doubt talk about it again when the Supreme Court hands down its judgments. We don't need to go to it in any detail, but I think it's worth thinking about that case. That case concerns whether you need to take account of the impact of the oil. So the proposal was for an oil field in the south of England, and the question is whether you need to take account of the carbon emissions that come from the off-site use of that oil once it's been sold off, and whether that is potentially an effect of the development that would need to be the subject of EIA. Huge implications if the Supreme Court says the answer to that is yes. And we'll deal with those in another session when we get the Supreme Court judgment. But I think it's just worth people being alive to that question of, well, actually, what is an effect of the development, and where do you draw that line? Are there downstream effects that may need to be subject of EIA? It's a really live issue. There isn't a clear answer at the moment because we're waiting for that judgment. But I just thought we ought to mention Finch in passing. But let's move on. We've talked about scoping quite a bit. So, Amy, perhaps you can kick us off. What is scoping?
It's basically follows on from screening, but sets out or makes a decision on what you're actually going to do, which topics are going to be relevant, and in what detail you're going to look at them. So you can ask for a scoping opinion. You can do that at the same time as screening or straight after. It's another thing that is consulted on, and then a local authority would hopefully adopt an opinion. So you don't have to scope, but it seems quite advisable to scope so that everybody's on the same page as to what you're going to be looking at through your EIA. If you have scoped, though, you have to base your EIA and your environmental statement on your scoping opinion. It's got to be the most recent scoping opinion that you've sought, that you base your ES on. Also to note, sort of touched on this a moment ago, but the scoping opinion doesn't mean that there won't be any requests for further information later down the line. It's still sort of open to the decision maker, be it LPA or Secretary of State, to request some further information if they feel they need to make their decision.
It always seems to me it's sensible to scope because when you're trying, if an EIA is required and you produce your environmental statement, that triggers a public consultation process, and therefore sort of it increases the decision-making time that's taken. If an ES needs to be amended, you have to go back through that consultation process, adding more time to the determination of the application. So I always think, actually, rather than guessing at what the planning authority wants, scoping has the benefit. You at least know what the planning authority wants at that point. Take your point, Amy. They may decide there are other effects later on. You can't sort of predict that, but at least you know. Otherwise, you're going to submit your ES. And the risk is you go through that public consultation, then at the end of it, the authority says, actually, we think you also need to assess these things, and you'll have to go back through that process, and that introduces delay. So it always feels to me sensible to go through that scoping. But Claire, what is it when you're going through scoping? What should be scoped in?
Yeah, so what should be scoped in is anything which is considered to be a likely effect of the development. And as Amy said, the local planning authority will consult with consultation bodies before giving their opinion, which should be tailored to the specific characteristics of the development and the main environmental features which are likely to be significantly affected. And once you have your scope and opinion, I think this is something that we've maybe all seen in practice is making sure that it's then reflected in your ES, and that you aren't you don't follow the temptation of potentially adding in additional topics which haven't been scoped in the scope and opinion, which could lead to unnecessary costs, could lead to potentially opening up risks that aren't there. You know, if you follow your scope and opinion, where you potentially carry out assessment of additional topics incorrectly. So as you said, I think it really is an advisable step to go through. And once you have it, once you have your scope and opinion, make sure that that's reflected in the document that you produce at the end of it.
And try to limit it. In theory, it should be limited to the likely significant environmental effects that were identified at screening stage. You do see that tendency, though. Again, it's that over-cautious approach of once you've said it's ES, then there's sort of almost there's a temptation.
You bring out your standard list of all your topic areas and just start.
Exactly, and it's like, well, hang on a minute, you just screened it in because there were likely significant effects on air quality and I don't know, whatever, heritage, but then all of a sudden you're wanting to scope in ecology and socioeconomic. You think, well, where? Because if they're not likely significant environmental effects, they don't need to be subject of EIA. They might need to be covered in other reports, but they don't need to be in EIA. So it's quite a key point. But once you've got that scoping opinion, if they have thrown the kitchen sink at it, is it possible to challenge that decision, Ian?
Well, no, the situation's not the same as under screening. So there's no sort of freestanding right to ask the Secretary of State to adopt a scoping direction. So if the local planning authority doesn't adopt a scoping opinion within 5 weeks, you can then ask the Secretary of State. But there is no right other than that. So just because you don't like the scoping opinion, you can't ask the Secretary of State to make a scoping direction. So that means obviously that you're limited in that sort of case to something like judicial review. I mean, I would imagine that it'd be very, very unusual circumstances that you would choose to do that, because generally you're better advised, I think, to simply to do the studies and to produce the ES in accordance with that scoping opinion. But I mean, I suppose there could be sort of edge cases. So you were just talking about Finch a moment ago, where there's still the possibility, I suppose, that the Supreme Court might open the door to things like greenhouse gas emissions resulting from the development to be scoped in. So if you have some sort of mineral development or oil extraction, as you just said, for the later sort of environmental effects, carbon emissions and so on, resulting from the burning of that to be scoped in. And in those sort of cases, I mean, I suppose it is conceivable. You could imagine that there could be grounds for a challenge in some circumstances, but I think that would be pretty unusual, to be honest.
Yeah, and given, Amy, what you said, if you get a scoping opinion, then it's binding. You are stuck at that point if you get the kitchen sink thrown at you. So actually engaging with the local authority around scoping and trying to assist the local authority to come to a sensible, pragmatic answer is always well advised, I think, to try and avoid that kitchen sink type approach where suddenly your EF is considering everything. That's key issues.
To a certain extent, I mean, the local planning authorities reliance on the information that obviously you give them, and the reality is that environmental consultants will tell the local authority what they think should be scoped in, and justify that. So you have some influence on the process. It's just unfortunately, as you say, I mean, the sort of defensive practice that's been adopted is for if there's any doubt, for things to be scoped in. And as you said earlier, I mean, actually, that's not always the best way to minimise risk. It's not always the best thing to just accept that something should be assessed, if there are reasonable grounds for saying that it doesn't need to be.
I think the problem as well, and too much being scoped in or too much being put into the ES, is that then it can obscure the actual issues. And there's some judge comment on that throwing the kitchen sink in and writing it really defensively actually isn't helpful, because it is obscuring stuff.
But it means you get these huge documents, doesn't it? I mean, environmental statements can just be, volumes and volumes of stuff, into the thousands of pages. And actually, I mean, even if you read the sort of the EU, European Commission guidance on this, it's pretty clear that, the EIA process is supposed to be focused on what will be the actual significant effect. So, if there isn't an effect on heritage, then we shouldn't just be assessing it because we're doing an ES. We only really need to assess heritage if there is a likely significant effect on that area. So, but it's because of the history of challenge and so on. It feels risky to a lot of people. So it's not sort of irrational to adopt that sort of practice, I think.
It's another reason perhaps to think about a screening direction. If you've had a screening opinion that lists lots of likely significant environmental effects, inevitably that's going to feed through into the scope. If you think that list is too long, then actually, because you can't challenge the scope, but you do have the ability to challenge screening, going to the Secretary of State and getting a shorter list, that might influence the local authorities' thinking in terms of scope. And it might give them the comfort of saying, well, actually, if the Secretary of State only thinks these three things are likely significant environmental effects, then there's a sort of logical route through to a shorter scope than might otherwise be the case.
It's low cost, isn't it, to do that? So I mean, it's almost a sort of why wouldn't you? Because it's not going to get any worse, is it? The council's giving you a long list of topics.
And there are some quite quick timescales for the Secretary of State. In most cases, there is an ability for it to extend, but there are some quite quick timescales for getting that answer back. I want to move on because I'm conscious of time. Assessment. Just very briefly, Amy, perhaps, is there any specific methodology that has to be used when carrying out EIA?
So assessment-wise, you should be using the most up-to-date methodology that's used for your bit. So if you were looking at, say, noise, you would use the most recent accepted noise assessment. Then there is a general process for the EIA to be undertaken, which ends up with this document, this ES that we keep talking about, the environmental statement, and that has specific things that need to be included. So it needs to describe the development and the environment and then the likely significant effects of the proposal on the environment. And then it will also look at the mitigation that we've talked about, and has to contain a description of reasonable alternatives to the proposed development. Also then a non-technical summary and other sorts of descriptions of location and physical characteristics. So in this, there are obviously the environmental factors that you've probably got your scoping opinion about on. If you've gone that way, then you just need to decide on the levels at which you're going to report on that. Obviously, just going back to that point about not reporting defensively and covering too much. If you've got a scoping opinion, sticking to what's in your scoping opinion, making sure you are based on that scoping opinion.
Thank you. And Claire, Amy mentioned earlier parameters, and I suspect most people are familiar with the concept of the Rochdale envelope, but it wouldn't be a talk on EIA if we didn't say the words Rochdale envelope. So just perhaps really briefly, what is the approach when you're dealing with an outline development? You don't have the detail of what's going to be built. So how do you approach EIA in that context?
Yes, as you said, it's the Rochdale envelope approach, which is something which came out of case law, and what that involves essentially is fixing your parameters at your outline stage, which set out the maximum extent of development which you're proposing, and this allows the EIA to be carried out using a worst case scenario approach. So just think about this practically, where you're preparing an ES in these circumstances. It's important to ensure that it's clear what those parameters are and that they're applied throughout the various topics that you're assessing. Appreciating that the more flexible that you're wanting a scheme to be, then perhaps the more time it will take for those assessments to take place, in order that the maximum adverse effects can be worked out. And it's really a balancing act as to how wide you keep your parameters in order to give you flexibility to develop as your design progresses, but also making sure that you don't go too far so that you could end up bringing in additional effects into assessment, which in reality you may never come into, because you're not actually going to build out to the full extent of those parameters.
Yeah, this whole Rochdale issue is the biggest reason why outlines are no longer just a red line on a plan, as they were. Those of us as old as me who remember the days when an outline literally was just a red line, and yes, you can have resi in there, that'll be fine, we'll worry about it at reserve matter stage. It's not like that now, and this is one of the big drivers, isn't it, is that parameter approach. I think that kind of worst case scenario, so Rochdale sort of says if you put your parameters and then assess the worst case, then you're there. I think there's always one to keep in mind is the test is the likely significant environmental effects, not likely significant adverse environmental effects. And so in theory, your assessment needs to also consider positive likely significant environmental effects. And that you just need to think about if you're taking a Rochdale approach, because it's not necessarily a worst case there, because it might be a positive effect. So you just need to make sure you're getting that right, and always keep that in mind, that it's not just adverse effects, although it tends to be the adverse effects that if you miss them, you get a challenge for. I don't often see a challenge because you fail to take account of the really positive effects on the environment coming from a development. But in theory, it's possible to do it, isn't it? The other area I just wanted to touch on briefly and around assessment is the question of cumulative impacts, because that again, I think people get confused sometimes about when to take account of cumulative impacts, what they are, and also how it all relates to the baseline for the assessment.
Yes, I mean, I think obviously those two concepts have got to be distinguished. I mean, the baseline is effectively the sort of the current environment, so that's what we're assessing the likely effects of the project against. Cumulative effects or cumulative impacts, I think, means probably two things in the context of the EIA. One is, how the different effects of the development will interact, and I suppose to give you an example of that. So the effect of the development on a species, for example, might include a loss of habitat, noise disturbance, and I don't know, impact on the supply of food or something. And in each of those impacts in themselves might not be significant, but together they might add up to a significant effect on the environment. So that's one sense that we can mean when we say cumulative effects. The other thing is obviously how the development might interact with other developments in the same area or in the zone of influence of your development. And Schedule 4 of the regulations says that an environmental statement has to assess cumulative effects. I don't think there's really a sort of a hard and fast rule on this, and it, as you say, it can get quite complicated. Just conscious we're sort of running short on time. I mean, PINS has got some very helpful guidance on this. So the Planning Inspectorate has a good guidance document in the context of infrastructure projects, which is Advice Note 17, and that provides a sort of a structured approach the way that they suggest that this issue of cumulative impact is assessed. It relates to infrastructure development, but there's no reason why it can't be used for other things in Schedule 2 that might not be sort of considered traditionally as infrastructure. I think the sort of rule of thumb in terms of assessing the project that we are concerned with other developments is sort of effectively how certain is this development to come forward. So, cumulative effects with projects that are under construction or that are consented, probably need to be taken into account. Those with applications in, probably arguably do. Others that are, that are perhaps less certain may not need to be taken into account. So I think that's the sort of general approach. But I mean, it's a complicated area, and it does, I think, depend on the particular facts of each case. If you're interested in this, as I say, as a viewer, I'd recommend having a look at Advice Note 17, which is available on the Planning Inspectorate website. So that is useful. It gives a sort of a structured way of thinking about how to approach that issue.
Thanks, Ian. So we've screened, we've scoped, we've done the assessment, and it all leads to the big moment. We get to the decision as to whether or not to grant planning. And so, Amy, perhaps if I can come to you, the ES has been submitted, all the consultation's being done. what does the local planning authority do with it next? How does it fit into the decision-making process?
Well, so obviously they need to examine it, have a think about it. They might need to ask for some more information, which they have the right to do so. And then they can take into account all of that information, or must take into account all that information when they're considering whether or not to grant planning permission. But it's all about a planning judgment. So just because there is a likely significant adverse effect doesn't mean that planning permission couldn't be granted. It just, the planning authority just needs to go through their decision-making process and balance any issues against any benefits to come out with whatever their decision is. So it's about taking those, having an eye on them and taking those effects into account, coming to a balanced judgment rather than them striking everything out just because something has come up. Not to say that couldn't happen, but
I think it's a really good point, and this is an area where you're in the hands of the planning authority, and if they get it wrong at this stage, even if you've done the EIA process right, if they get it wrong, then you've got that risk of challenge to planning permission. So it's always worth trying to work with the planning authority here. Quite often, a planning authority will be willing to share their draft officer's report with the applicant, and that I would always encourage that, and get your lawyers then just to look at how the officer's report is dealing with EIA. In order to try and make sure that it's being done in the right way, because I think ultimately the planning authority needs to be satisfied that it's got sufficient information in front of it to understand the likely significant environmental effects, and then it needs to take into account those likely significant environmental effects. And I think this is a really big point for me. There's always a tendency to try to make sure that your EIA shows that there are no likely significant effects, particularly adverse effects. And there's almost a pressure and a sort of a feeling that the document needs to come to a clean bill of health at the end of it. And that's not the case. It's not like habitats regs, where if you've got a problem, you can't grant. Ultimately, all the planning authority has to do is to take account of any likely significant environmental effects. In that process, they may well come to the conclusion that yes, there are these likely effects. However, other matters outweigh it. And that's good old planning judgment, planning balance. Ultimately, they've got to decide section 38.6, determine in accordance with the development plan unless there are material considerations that indicate otherwise. Your ES might be one of those material considerations, but it's just a consideration that needs to be in the balance. It isn't an overriding driver that because there's a likely significant environmental effect, that must lead to a refusal. And so I think if you try and take that approach, actually you can start to undermine the credibility of your environmental statement and open up a risk of challenge. So sometimes, slightly counterintuitively, the lower risk approach might be to just fess up. Yes, there is a likely significant environmental effect on air quality, or yes, there is a likely significant environmental effect on water quality, or whatever. But then go through that decision-making process and allow the local authority to decide whether that effect is of sufficient weight to justify a refusal. And that is a much less risky process in terms of challenge, because ultimately you're then into the realms of planning judgment. It's very hard for anyone to say that the weight that the planning authority attached to that likely significant environmental effect was wrong, unless they're completely irrational. As long as they've taken it into account, that's enough. So I think it's a really key point in the process is to just remember that we don't have to show that there are no effects. We simply have to take into account the effects that there are. And that is pretty key for me. We've got 5 minutes left. Let's try and do one more topic really briefly and then perhaps see if we got time for some questions. So Claire, I'm just going to come to you. We've been talking throughout about this is EU law, but we've left the EU. This is one of those areas that a few months ago we were going to have swept away all of these regulations by the end of this year, and that's obviously, as anyone that's been following the news will know, that's not the case anymore. The government's backed off from that, but nonetheless there are some proposals, aren't there, around potentially replacing the EIA regime with something else. So can you just in a minute tell us a quick overview of what those proposals currently are?
Yeah, so these proposals are in the Levelling Up and Regeneration Bill, the LURB as we've been calling it, and the proposal is to implement a new system of assessment, which will be known as environmental outcomes reports. So they are going to be, as we understand it from the information that we have, written reports which set out the extent to which proposed development is likely to impact on the delivery of specific environmental outcomes, which will be set by the government, and then the steps proposed for the purposes of avoiding, mitigating, remedying, or compensating for non-delivery of an outcome. We don't have a great deal of information at the present, because this is all going to follow in secondary legislation in the event that the LERB gets through Parliament. So no doubt it's going to be an outline session to come at some point in the near future.
Assuming the LERB makes it through Parliament.
Assuming it will, yeah.
The general election is getting ever closer, and there's no sign of the LERB particularly making progress. But we'll see. At some point, someone will try and replace the regime. Thank you. We've got just a couple of minutes left. Just trying to pick up on some questions. We've had a few questions. First one is, if you're seeking a screening direction, does that prevent you from making your planning application? Do you have to wait for the Secretary of State to make the decision? I think the answer to that is no, you don't. But you just need to be aware, if your planning application's in, if you end up with a positive screening direction, or indeed if you end up with a positive screening opinion, that the clock will then stop in terms of the statutory time periods for determining your application until you've submitted your ES. So there's never a requirement to screen pre-application, but if you don't, the planning authority should do it automatically, or the Secretary of State on appeal. And if the decision is that EIA is necessary, then your determination period stops until you've done the ES. But the answer to the question is no, nothing stops you putting that application in, unless anyone disagrees with me on that.
No, agreed.
Jolly good. That's relief. The last one, with 2 minutes to go, this question is just too big. Has there been any more recent case law around consideration of alternatives in EIA? The answer, I think, is there's always case law around that, but we're never going to get that done with 30 seconds to go, and we do always stick to our hard stop. So by all means, reach out to us afterwards, and any one of us will happily talk that through if you're interested in the case law on alternatives in EIA. But I'm going to end it there. Thank you to everyone for being in the audience, joining us today. Special thanks to Amy, Claire, and Ian for joining me. It's our summer holidays next month, so we will take August off, but Outline will be back in September. So look out for further details of the topic over the next few weeks. But in the meantime, thank you all and goodbye.